with us here today Jeff Brekke from May & Johnson Law Firm in Sioux Falls. And Jeff practices in the areas of business law, real estate, contracts, estate planning, and probate, mainly. He is a graduate of our law school here, and he also has his CPA certificate. He has done many presentations at the law school and for the state bar in the areas of business law and estate planning. So he's an active member of the business law committee for the state bar. So he's very qualified to present today our topic of business entity sales. Just on a personal note, Jeff and his wife, who's also a lawyer, have 3 daughters. Their oldest was my law school classmate, and she's extremely bright and extremely talented. So I know, in addition to being a experienced and well-qualified practitioner, he's also a proud dad. So we're happy to have Jeff Brekke to do our presentation today.
Thank you, Mary. Just a quick note on my oldest daughter. I am very proud of her, but being smart and all of those things, as you'll find out quickly, all of that came from my wife, so she was fortunate. Let's see. Be sure, if you have any questions, ask as we go. I'm glad to try to answer them as best I can. I think your last session was Amy Arndt, and she dealt with forming an entity. Now we're going to quickly sell it. I've done, over my years of practice, probably 45 of these transactions. I find it a lot of fun. You get to learn a lot about a business. You get to learn a lot about the people and the players in the business. I've sold beer distributorships that covered eastern South Dakota, grocery store chains that have gone for like a 3-state area, a small chiropractic business. So I've kind of done the gamut. And again, I find it fun. If you're representing the seller, oftentimes it's a little bit of they're selling their baby. If they formed the entity and made this a great business and now they're going to sell it, sometimes it's a little cantankerous at the end because the buyer may not see all of the great things that the seller has done or appreciate them to the extent that the seller thinks they should. I found that when I make this presentation, it's a heck of a lot easier if I just focus on corporations. But you aren't limited to that. If you're going to sell a business, you might be representing someone who has a sole proprietorship, a partnership, a limited partnership, a limited liability company. The concepts are all going to apply, but we're going to, most often, I think in South Dakota anymore, you're going to deal with corporations and limited liability companies and closely held entities. The terminology also may differ. I'm going to refer to shareholders, but if you've got a limited liability company, you're going to refer to members, membership units instead of shares. But again, conceptually, it would be the same. Okay. That I mentioned the unique issues that are presented. I'm going to focus a little bit as I go along on a couple of things, inventory being one of them. Well, I gave you the example of selling the grocery store business. Inventory was a huge thing in that transaction. There's a company that is called Regis, and what they do is they count. So when we sold this grocery store chain, and there were like 15 stores throughout the 3 states, we just had to supply enough people to go to each store. Okay, how many cartons of eggs do we have? How many hams do we have? Da, 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 da. That was a huge production that had to be done kind of right, and some of these stores were 24-hour stores, so you had to have this count and have a closing quickly thereafter, because the price was based upon an inventory value, or that was a problem with the price, maybe is a better way to say it. Let's see, there are certainly, if I hit that already, no, go back one. Okay. I have not tried to cover here, I think we'll have enough to talk about, but I haven't tried to cover valuation issues. Haven't tried to cover securities laws considerations, income tax specifics. I'll talk just in general about those, or antitrust considerations. But in a closely held entity, you're probably not going to have antitrust, and you're probably going to rely upon an accountant. I think an accountant's an important part of the team to buy and sell assets of a business, so they can help with the tax issues. Okay. If we've got an entity and now somebody wants to retire or they want to sell their business for whatever reason, who might buy it? Well, certainly you might have other shareholders, employees, customers, competitors, investment groups, and other franchisees if there's a franchise involved. So you've got a lot of different options. How are you going to try to sell it? Well, it might be word of mouth. There are business brokers, just like there are real estate salespeople. You can list with a business broker who will list your business for sale. You can put it in a trade publication. You could put it in the newspaper. You could do it whatever. You want to, I think, if you're representing the seller, be a little bit careful on how you do it, because if the customers see that you're wanting to sell, sometimes the customers then decide they're going to go to another business. So you want to be a little careful there. Valuation. Okay. There are accounting firms, not limited to accounting firms, but they're the most common ones, where they have an arm of the accounting firm that does business valuations. And you can do a business valuation for all sorts of reasons. Maybe one is to sell the business. Maybe another one is for federal estate tax purposes. Maybe another one is for a gift tax purpose or reason. You want to figure out what's the value of a share because mom and dad want to give some of the shares to a son or daughter. You can get an appraisal. There's industry standards. An example might be, in a certain industry, it's common to sell the business for 3 times, a weighted average of the last 3 years net income, or whatever it might be. You can use a business broker who usually can give you some input. The SBA has a little formula for figuring out what values of a business are, and you plug in all the numbers on what's the inventory and the sales, etc., and they spit out what they think it's worth. You can, if there is a franchise involved, you can certainly contact the franchisor, and as a general rule, they're willing to help you figure out what that business is worth. If we're going to sell a corporation, this distinction is important as to what you're going to do. And I noticed last year in the assignment that I gave, people just get confused or don't realize the importance of the distinction. Maybe that's a better way to do it. If I have a corporation that I own stock in the entity. The entity is the one that owns the assets. The vehicle that's part of the entity, I don't own that personally. If I looked on the title, it wouldn't say Brekke, it'd say ABC Inc. or whatever. So I could, if I own this business, sell to Marilyn the business by selling her my stock. If I owned 100% of the stock in ABC Inc., I sell to Marilyn my 10 shares or 100 shares, doesn't make any difference. If I own 100%, I'm selling her all my shares. Now Marilyn owns this business. That's a stock sale. Instead, I could sell to Marilyn the assets. Well, in that case, it's not Brekke selling to Marilyn, it's ABC Inc. selling the assets to Marilyn. That is important, and I'll talk a little bit about the ramifications and where you end up with most entities wanting to, what they want to do here. If it's a stock sale, now the entity will continue to own the assets, as I mentioned, and Marilyn would own the stock instead of me in my example. Usually, this isn't what a buyer wants. So if you're representing a buyer and they say, you're representing Marilyn, I want to buy Brekke's business, you're usually going to say to Marilyn, you know what, I don't think we want to buy Brekke's stock. We can still buy the business. I think we'd rather do the assets, but we don't want to buy the stock. And the reason for that is that if Marilyn buys the stock, she's got all of the skeletons that are in the closet of my corporation. And so most buyers say, I don't want to do that. Now, there are times when you do need to have a stock sale, or you might want to. And I put up a few examples. If I had a net operating loss, she may want to buy the stock so she can get that net operating loss to carry forward. Maybe there are some insurance ratings that are favorable that she's better off buying the stock. Maybe I have a lease that was poorly prepared by the lessor that says I cannot assign that lease, but it doesn't say that I can't sell the stock. So maybe we want to get around the anti-assignment provision in the lease by me selling the stock, because from the lessor's perspective, it's still ABC Inc. is the lessee, even though there's a new owner of ABC Inc. If you're going to buy the stock, because as I mentioned, there are times when it does make some sense, then you're representing a buyer, you're going to want to make sure that you go extra effort to make the agreement include provisions whereby the seller is making a representation that there aren't any liabilities, or if there are, they're specifically set out on the financial statements or an exhibit or whatever it is. That still doesn't promise you that we've got all the skeletons. Number one, maybe I wasn't forthright in telling Marilyn what's out there. Number two, maybe I just didn't know that there were these skeletons out there. If I was in the business of putting in underground pools, for instance, well, that's probably a high liability business, and maybe I don't know that I've got a bunch of people getting ready to sue me for my poor workmanship. So you want to make sure your agreement does the best darn job you can to say sellers told you everything about liabilities, but then I think you want to go a step further and say, well, now wait a minute. I was going to pay you 100 grand, Brekke, for this business, but because I'm nervous about what the heck might be out there in the skeleton category, I'm going to, at closing, not pay you 100 grand. I'm going to pay you 75 grand, and we're going to escrow the other 25 for 9 months or some period of time and see if any of these skeletons, any of these liabilities come out of the woodwork, and now we've got money to look to take care of those liabilities. If instead all the money's in my pocket and I ran to Vegas, well, Marilyn might have a claim against me, but I just lost it all in Vegas. What good's that claim going to do us? That last comment I'll maybe expand on a second. You're probably going to have an indemnification provision in the agreement, a cross indemnification provision that would say that I, seller, am going to indemnify Marilyn for liabilities that I didn't tell her about that she's stuck paying. But again, if I took the money and blew it all in Vegas, what good is that indemnification provision? It's good lawyering, but I think you might want to go the extra step with this escrow. Then usually, if there's a closely held entity that's owned by more than one person and the owners are not husband and wife or family members, there's usually a buy-sell provision. I gave you a simple example where I own this business and I'm selling my 100 shares, which is equal to 100% to Marilyn. But let's say instead that my daughter and I own 100 shares, me 80 and my daughter 20. Marilyn might say, you know what, I'll just buy the 80 from Jeff because my daughter didn't want to sell. And I'm fine with that from Marilyn's perspective because I own 80%. I control this entity. When we need to vote on something, I call on the shots. But in representing Marilyn, you'd want to say, well, now wait a minute, Brekke, is there a buy-sell agreement that may prohibit me from selling to Marilyn without a right of first refusal kicking in the buy-sell agreement? So, yes.
Conversely, a lot of times if you're a majority shareholder like that, when you have a drag along or a tag along right, I guess in this case probably a drag along right, so that you can drug along if somebody tried to sell out the majority shareholder, because oftentimes a minority shareholder doesn't have much value.
I think that's true, but I mean, you could by an agreement have this drag along right that you're talking about, but that's usually not the case. If we've got a deal where you and I own the business and I own the majority and I want to sell and you say, that's the dumbest idea I've ever heard. I want to sell for too little. I'm old, you're young. You know what I mean? I just want to retire. Then probably what I'm going to have to do in the controlling spot is to say to Marilyn, well, unless you're willing to just buy my shares, if you want the whole thing so you can do it, we're going to have to do an asset sale. And now, asset sale will have a vote on it. I'll be able to outvote you. You'll have minority shareholder rights to get an appraisal, etc., if you want to go that route. That answer it?
Yeah.
Okay. Okay, asset sale. Again, most of the time in representing a buyer, that's what you're going to want to recommend to your client. The seller doesn't really care. I mean, if I sell my stock or I sell the assets, that's not a big deal to me. This asset purchase versus a stock purchase is driven from the purchaser's perspective and the skeletons in the closet kind of a thing. So after the closing now, the buyer is going to own the assets it purchases. And if you're buying a business, you don't have to purchase all the assets. Usually you're going to purchase substantially all of them. But let's say there's these 10 vehicles and 3 of them are a piece of junk. You could say as a buyer, I don't want to buy the junkers. You keep them and do whatever you want to with them. And now the buyer's only going to be liable for any liabilities that they assume. In an asset sale, it's pretty common that the buyer is going to assume some liabilities. Let's say you're leasing, I am the seller and I'm leasing a photocopy machine. Well, if the buyer is going to come along and say, yeah, this photocopy machine's fine and the lease is fine, the buyer is going to then assume that lease. If I'm operating out of a leased building as a seller and the buyer doesn't have anywhere else to go, the buyer is going to probably assume the lease on the building, and now that's a liability that they are assuming. So there's nothing wrong with assuming liabilities. I don't want to give you that idea. It's just that in an asset sale, you're going to call them out specifically in the agreement so that we know exactly what we're doing, and now you don't have to worry about the skeletons in the closet. Okay. That's just a little bit of the background. Now let's get into the specifics of doing it. And if you're lucky enough to have a client who comes to you early on in the process, and assuming you're representing the buyer or the seller, and it doesn't always happen that way. Oftentimes I come in with, or clients come in to me, hey, I struck a deal to sell the business and here's the 10 napkins we wrote the deal out on. And now I've got to deal with it. But if you're lucky enough to have them come in early and you're representing the seller, you're going to want a confidentiality agreement where you say, okay, I'm going to open up my books and let you prospective buyers look at my financial statements, income tax returns for the last 5 years, see my customer lists, walk around, see my employees, etc. But you don't want to do that as a seller, in my mind, without a confidentiality agreement, because if the negotiations fall apart, you don't want this buyer now having learned all about my business and either blabbing it around town or instead going up and starting up their own competing business with me. So we're going to want a confidentiality agreement. Letter of intent. Okay, what is that? Usually what happens is before you're going to be able to prepare an agreement, the parties will have negotiated what's going to be the purchase price, what are going to be the assets, what are going to be the liabilities, is there a non-compete, how long is it going to be for, who are the parties that are involved. There's going to be all sorts of factors that they'll have probably negotiated themselves where they don't really need you to do that. Some clients want you to, but as a general rule, they don't. All right? The letter of intent is at the point in time where they may have struck their deal in general terms, and they want to make sure that everybody's on board before they spend a bunch of money with the attorneys to draw up the agreement and go back and forth on the language of the asset purchase and sale agreement, etc. So we'll do a letter of intent that's maybe a 5-page document. Where the asset purchase and sale agreement, I've done 50-page documents. So we might have a 3 to 5-page letter of intent. That's going to, again, have the general terms of the deal. But I don't want to give you the impression that you have to have a letter of intent when you sell a business. You don't. And you don't have to have a confidentiality agreement. And I suppose you don't have to have an asset purchase agreement. You can do one verbally, but on that last one, I sure think you've got a client who's not thinking well. But the letter of intent is helpful in some deals, and I usually find it happens when I've done some of these, the beer distributorship, the multi supermarkets, and when we're going to talk 20 to 50 million bucks for your business, maybe we ought to have a letter of intent before we go a whole lot further to make sure everybody's on the same page here. I mentioned a couple of these, but in that letter of intent, it's just going to be in general. The parties have had preliminary discussions. They agree that they're going to sell, Joe's going to sell, Pete's going to buy, and the price is going to be $2 million. It's going to be all paid at closing or whatever the rules are. If it's a stock, how many shares? If it's the assets, you're going to summarize the assets. They're going to purchase the inventory and accounts receivable or whatever the assets are going to be. It's going to say that the buyer and seller are going to agree to proceed in good faith to enter into an asset purchase agreement, because that will be our next step. And it should specify that it's non-binding. On that non-binding concept, that's true, that normally a letter of intent is non-binding, but if you haven't already had a confidentiality agreement, whether as a standalone when you started the whole thing, or as part of your letter of intent, you need one, you need one in the letter of intent if you didn't have it standalone. And you're going to want to say, this is non-binding except for section 23 or whatever it is, that's the section dealing with the confidentiality. That part you do want to be binding. Yes?
Is it common for you to also, depending on the type of business, especially if you're representing the buyer, to want to put in a no shop provision that might be binding for a certain period of time? Or do you just kind of assume that the parties are going to be dealing exclusively with just one of them?
Well, a no shop provision, meaning you want to bind the buyer that they can't go to other people?
Bind the seller.
Oh, the seller. That's very common. You're going to want to say that the seller cannot negotiate with anybody else during this period of time. But you're probably going to want to put a limit on this letter of intent. Hey, if we don't have a purchase agreement in 8 weeks or whatever it is, then the deal's off. All right, asset purchase and sale agreement. Kind of mentioned this a couple times before. We're going to focus on an asset sale. We're also going to focus on a closely held corporation. You're going to have the similar concept, similar kind of an agreement if it's a stock purchase and sale agreement, but it gets too jumbled up if I try to say all of those words each time. Okay. Before I go into this next one, the assets sold and assigned, this is another thing that I noticed last year in the assignment that students just were not clear about. So I thought I'd spend a little time because I think this is pretty important. You need to be able to identify who are the parties to an agreement. So if you can read my scribbles over here, with all these lights maybe it's hard to see, but if we say Sam Smith and Sarah Smith own Suds Inc., that's going to be the seller. All these S's, that'll be the seller. And Bob Best and Beth Best own Best Inc., all of these will be the buyer. Okay? If we're going to have a stock purchase and sale agreement, either Best Inc. or Bob Best and Beth Best are going to buy the shares owned by Sam and Sarah. Okay? But if instead we're having an asset purchase agreement, usually, not always, but usually you're going to want to, when Bob and Beth come in and say, hey, we want to buy Suds Inc., you're going to say, well, I think we ought to buy the assets, number one, so we don't have liabilities. Number two, you're going to say, you know what, rather than buying them personally, I think we ought to form an entity. So maybe the first step you're going to do when they came in is you formed an entity called Best Inc. Amy told you how to form an entity. So now, if you're going to prepare an asset purchase agreement, who are going to be the parties to that agreement? Well, it's going to be Best Inc. And Best Inc. is going to be the buyer. But what I saw in the assignment last year, I keep going, Marilyn, and you want me to shut up for a minute? Can people see my scribbles? Okay, I think we're all right. When I had the assignment last year, the papers I got back were, the parties were, got my people again. Bob Best and Beth Best do, on behalf of Best Inc. Bob Best and Beth Best. I got unfortunately, the majority of people didn't know who in the world the parties were. Well, Best Inc. is the buyer. And when we get to the signature block, I don't put Bob Best for Best Inc. I do Best Inc. by, and then Bob Best is president. That, the party's Best Inc. The signature block is Best Inc. by Bob Best, its president. You got to understand that it's not the individual, because that's why I formed my entity, to keep my personal assets or my personal liability limited. If I form Best Inc. and run around and sign everything Bob Best, I'm signing in my individual capacity with an individual hat on. I've just thrown away all the limited liability that I supposedly was trying to get by forming the entity. So if we had a simple deal that Best Inc.'s going to buy the assets of Suds Inc. and stop there, those would be the two parties. Suds Inc., then I usually put parents hereinafter referred to as seller, and Best Inc., parents hereinafter referred to as buyer or purchaser, whatever the heck you're going to do in your agreement. Now, let me expand on that for a minute. It's common, and I'll come back to it, but it's common to have the representations and the warranties in the purchase agreement being made not only by the seller and the buyer, the two corporations, but you oftentimes have the shareholders join in on those representations and warranties. And one of the reasons you want to do that is when the dust settles, we get this transaction closed and everybody walks out and has a big, nice dinner and they're all happy. Well, if things go south and people want to sue each other, I don't know that Suds Inc.'s going to exist anymore. Remember, Suds Inc. sold all its assets and it gets a big chunk of dough and it distributes the big chunk of dough to its shareholders, Sam and Sarah. Sam and Sarah run to Vegas and blow it all. Well, hopefully they don't do that, but at least I've got them personally on the hook. Otherwise, Suds Inc. would have got the money, made the distribution to the shareholders, and now you're going to sue Suds Inc. Hey, I don't have any money left. The other thing that's involved is it's common, not all, you don't have to, but it's common that with an asset purchase and sale agreement, you're going to want to bind the owners, shareholders of seller, to non-competes. Well, they're doing that with a hat that says Sam on, and Sarah's doing it with a hat that says Sarah. So you're going to have a non-compete for Suds Inc., for Sam Smith, and for Sarah Smith. So even though I put, or told you just a minute ago, a real simple vanilla, more vanilla than vanilla, there is such a thing, and that transaction would be Best Inc. and Suds Inc., it's pretty common that you're also going to have as parties Sam Smith and Sarah Smith with an individual hat on. Don't say the party is Sam Smith as shareholder of Suds Inc. It's Sam Smith with an individual hat on, and probably Beth Best and Betty Best, which I'll learn on my example next year not to do all those B's because I can't say them. They're also going to be parties. So it's in this transaction, how many parties do I have? 1, 2, 3, 4, 5, 6. So in the document, you're going to start out, this agreement is made and entered into as of forgot the date, February 29th, 2016, by and between Suds Inc., hereinafter referred to as seller, Best Inc., hereinafter referred to as buyer, Sam Smith and Sarah Smith, collectively referred to as seller shareholders, Bob Best and Beth Best, collectively referred to as buyer shareholders. Something like that. That's going to be your introductory paragraph so I know who in the world the parties to the agreement are. That concept comes through 3 times in an agreement, at least twice, but maybe 3 times. And I think in that sample agreement, it's a 3-time deal. In the agreement itself, you're going to have numerous sections. One of them is probably a notice section. If somebody wants to send a notice of default, somebody wants to send a notice about whatever, you're going to have, how do you do it? Does it have to be by registered or certified mail, blah, blah, blah. If you're going to identify the parties in that notice section, then you're going to have the same 6 parties that I just referred to. I mean, sometimes I'd have last year the people would get the parties right in the introductory paragraph, and then the notice paragraph, they only had Best Inc. and Suds Inc. or whatever. No, you'd have all 6. And then when you get to the signature block, again, you got to carry that concept through, or blocks. You're going to have 6 signature blocks in the example that I just gave you. For the entities, they're going to look like that. Then there's going to be, for Bob Best personally, that's just going to be a real simple signature line. It'll be Bob Best, and then he'll sign it. Okay. Hopefully that helps. All right. Now we've got the introductory paragraph as to who the parties are. Usually you're going to have some recitals, whereas seller and buyer have had negotiations and seller owns a business called Suds Inc. that operates a local tavern or whatever the heck it is, washing machine place, whatever it is. And they want to enter into this agreement whereby buyer is going to buy seller's assets. Now we're going to have the different sections of the agreement that I'll try to go through. Okay, what are going to be the assets purchased and sold? I've got some examples up there. You don't have to have all of these categories in every deal. Every deal is going to be unique. And what do people want? Because you don't have to buy all the assets. But the equipment, furniture, and fixtures, you're probably going to have a list of those. And you don't want your client to spend money for you to go out and take a little inventory. Let's see, there are 43 chairs in here and da-da-da-da-da. Let the client do all of that, and they'll give you a list, and you'll refer to that in your document as listed on Exhibit 1.1 attached here to and made a part hereof by this reference, as an example. Real estate. Well, maybe there is no real estate being bought and sold here. If I, the seller, Suds Inc., am renting this facility that I'm operating the bar out of, I can't sell real estate. All I can do is assign a lease. But maybe the transaction involves one where I, the seller, owns some real estate, the purchaser's going to buy it. Maybe the purchaser, even though I own the real estate, the purchaser says, I don't want your real estate, or I can't afford it. I'm going to lease it, or I'm going to go elsewhere. Leases, contracts, and policies. Okay, if you're going to assume leases, we talked about assuming a lease of the physical location, assuming the photocopier lease, etc. Those will be assets. Inventory. Describe and count prior to closing. I gave the supermarket example where we're going to have to deal with a big section of the agreement on, hey, we've got to count all this junk, and we're going to hire Regis, and we're going to do that on a Friday night at 8 p.m. because that's the slowest time in the grocery store, and then we're going to close on Saturday morning at 8 a.m. because that's still That's not a slow time. I think that's the busiest day of the grocery store, but you get the point. All right. Let's see, supplies. Make sure I did that. Oh, okay, that's fine. Supplies, maybe a big deal in this business, maybe not. Accounts receivable, I'll spend a little bit more time later, but that's something that maybe you don't want to buy the accounts receivable. Maybe you do. And there are some pluses and minuses, and there are some gives and takes from the perspective of each of the parties as to how you want to do that. Usually, not always I suppose, but usually the buyer is going to want to acquire the name of the entity. If we're buying assets, anybody have an idea? Is Suds Inc. an asset that I have an absolute right to sell? That name? Anybody want to venture a guess?
Yes.
Why? How do I get it right? How am I proving the title to that deal? The questions were probably poorly crafted, so I apologize. No. Here's where I'm going with that. You're going to get that name by applying to the South Dakota Secretary of State, as an example, or Nebraska Secretary, etc. I don't have an automatic, that's not mine forever to put in my pocket. That's a name that they approved me using that name. So if the buyer wants Suds Inc. in my example, I can't promise I'm going to do that, but I can say in my agreement, okay, that's fine. Here's what I'll do as the seller. At closing, I will promptly send in articles of amendment to my articles of incorporation to the South Dakota Secretary of State to change my name from Suds Inc. to ABC Inc. And you, buyer, can write alongside of me, or maybe we'll both drive to Pier, or whatever we're going to do. You can submit articles of incorporation to change the name of Best Inc. to Suds Inc. So we'll do one, boom, second one right there. Now I can assure that that buyer is going to get Suds Inc. That may be, I wasn't trying to say you can't assure it, but I can't necessarily say I'm going to sell that asset. But normally the buyer is going to want that because there's probably some goodwill associated with it. The goodwill, I'm going to come back to that later, but that's a big deal. And if you don't refer to the goodwill as being an asset in the business, you're making a mistake. Especially if you want to do a non-compete that I'm going to come to later. But that's important. Telephone numbers, fax numbers, websites, email addresses, cell numbers, all those kinds of things, I'm guessing you're going to want to have as representing the buyer. And again, with the telephone number, we'll do the rigmarole to switch the number. But you're going to want to cover that in your agreement. An unemployment insurance account. If you have a business in South Dakota, you pay premiums for unemployment insurance. You get a rating. And if you've been in business for a long time and don't have a lot of employees who are leaving you or you're firing them, your rating is going to be lower, and you're going to have this unemployment insurance account with a dollar amount sitting in there. And that's something that as the seller, I can't do anything with other than take it and put it to a new business. So if I'm going to sell this bar that I'm selling, and I'm going to take the dough and open up an ice cream store, I can take my unemployment insurance account with me. But if I'm going to go fishing or golf or whatever I'm going to do and retire, that unemployment insurance account does me no good. But it's an asset that you would want to list if you're representing the buyer, because if you don't, I've run into transactions before where I'm representing the seller, the buyer doesn't think of this, the buyer's attorney doesn't realize that I didn't volunteer it, I wasn't hiding anything, but it didn't volunteer it, they just didn't list that as an asset that they wanted. And now things kind of went, the parties don't like each other, and we're getting to closing, and the buyer wants the unemployment insurance account because the light bulb went on, and my client has said, not going to happen. They want it, they're going to pay me for it. So you need to list it if you want it. Not every business, my bar probably doesn't have any patents, copyrights, trade secrets, or know-how, but if you're selling a business, it's a manufacturing business, there's tool and die work and all that, you might have some of that. So you're going to want to presumably list those as assets and figure out how in the world are we going to get those transferred. Permits, licenses, and rights. Usually the seller is going to retain some assets. If I've been, I'm not a smoker, but if I've been driving around this 2000 Ford, whatever, since I bought it new in 2000 and I smoke in the car, well, I'm guessing the buyer doesn't want that car, and I'm probably going to keep it. My personal computer that I have at work, I'm going to probably want that because I've got all my personal emails and blah, 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 blah. Well, that's fine. I can have that, but we're going to get all of the stuff from the buyer's perspective. We're going to get all of the stuff about the business off of my personal computer. We don't want me being able to do anything with that after the closing. Let's see, cash. If we're going to sell the business for $100,000 and I have $10,000 in cash as the seller in my bank account, well, it wouldn't make sense to say let's have the purchase price be $110,000 and then the buyer gets that account. We're just going to probably say cash and cash equivalents are retained by the seller, and we're going to figure out a price excluding those kinds of things. Again, I mentioned real estate before. Maybe the buyer is going to take the business and go elsewhere. Maybe the buyer can't afford the real estate. So we're going to list the things that aren't being sold. We're going to want to clearly identify the liabilities that are being assumed. And you kind of, from the buyer's perspective, do it by exclusion. We're only assuming these liabilities, and you list the 3 or 4 or 10 or 30. I don't care. But you're going to say every other liability, unless specifically listed right here on this list or in this agreement, is being retained by the seller, and buyer has no liability. As a general rule, that's going to work. There are some exceptions whereby there's a continuing entity. You can screw it up if you really don't follow the right procedures, but as a general rule, buying assets, you don't have to worry about the liabilities that you didn't specifically assume and identify. Okay, we're going to have sections on the purchase price and how do you pay it, how will you allocate it. The allocation concept I'll come back to in a minute. Now, I guess I'm going to come to each one of those. All right, the determination of the purchase price. It's easy in my example, $100,000 for the bar, okay? But not every transaction is going to be that simple. When I have the supermarket example, we're going to do the inventory. We don't know what that is today. Usually you're going to sign the purchase agreement today and close like in 60 days or 90 days. We have no clue what the inventory is going to be at that moment in time. So we got to have a formula for the purchase price. So I gave an example there in that little outline or up on the screen if you want. Maybe the purchase price is going to be, and you're going to have to write the formula, write a mathematical formula, which sometimes is harder than it might seem. But $500,000 the parties agreed in this example, plus the inventory value at closing. And I said 5% of the laid-in cost based upon a pre-closing account. Well, what does that mean? The concept is this. The seller acquired all of this inventory and now it's sitting on the shelves in the supermarket, or it's in the back room for the computer sales place, or whatever it is. They probably got its costs tied up in addition to the actual money that they paid for this inventory. So the 105% is supposedly trying to compensate that seller for those additional costs. Doesn't have to be 105, but that's the concept of why I use that number. Then it says the formula continues, plus the accounts receivable value, and I said 85% at closing. Well, what's that percentage about? If there's 100,000 in accounts receivable, shouldn't the buyer have to pay me 100,000? Well, the concept is this. Most businesses don't collect 100% of their accounts receivable. So probably you look at the historical collections percentage of this seller's business, and if it was about 85%, you'd say, wait a minute, seller, you were only going to probably collect 85 grand. I'm not paying you 100 grand. That's silly because I'm losing that money. So we write the formula to say 85% of face value of the accounts receivable. So before closing, there's somebody scrabbling around in the seller's company, printing out the list of the accounts receivable, each item. Who owes it? John Smith, has a tab at the bar, da-da-da-da-da. We get all of those, we total them up, and we take 85%. That's going to be the amount paid at closing, but we don't know that today, 60 days before closing, plus prepaid rent. And again, will there always be prepaid rent? Of course not, but I just gave an example of a formula that might be used. Okay, how is it going to be paid? Not uncommon to have money in escrow when you sign the purchase agreement, but it doesn't have to be. It's usually a modest amount. And the reason that it's not that big of a deal is, I'm going to come back to it in a few minutes here, but usually the purchase agreement has a big enough hole for the buyer to back out of the deal that you can drive 30 tanks through it. And that's okay. But we'll come back to that. So you may or may not have a down payment. You don't have to. Our balance is paid at closing. Maybe it's not, but if it is, that's what you're going to say in your how do you pay it section of the purchase agreement. If instead you're going to say, well, some amount's going to be held in escrow for a period of time, well, you'll say that. If you're going to have seller financing, you're going to have to refer to all of the issues that would be associated with that. If you're representing the seller and the buyer says, you know what, I can't get a bank loan, I don't want to get a bank loan, I don't have the cash, my family won't lend me the money, whatever the reason is, they're asking your client, seller, to act to be a bank. That's really what you're doing. If you're going to pay $100,000 for the business, but you're only going to give me $10,000 at closing, and I've got to carry 90 grand as the seller, well, I'm going to need stuff. I'm going to need a promissory note. What security am I going to get? Guarantees, that kind of thing. Allocation of the purchase price. You've got competing interests from the buyer and the seller. So the IRS is going to, if buyer and seller come to an agreement, the IRS is going to say that's fine with us. The seller is going to want to allocate the purchase price to assets that will produce capital gain or ordinary loss. Land, building, goodwill. Those kinds of assets give you a capital gain. Buyer instead wants to allocate things to assets that they're going to be able to quickly write off or get back. If they allocate a bigger amount to the building than needs to be, and they're buying real estate, they can depreciate it, yeah, But how many years? 30 years. They're going to want to maybe put it in inventory so now they can sell it and write it off quicker. So the parties have competing interests in how they want to approach that. Representations and warranties section of the purchase agreement. That's probably the most important, or one of the most important sections in the whole darn thing. We're focusing on asset sales, important, but even much more important if we were selling stock. But that's the basis for a post-closing lawsuit if you're representing the buyer. So you're going to want to think through from the buyer's perspective what things are important. And so I tried to give some examples here. Some of them are kind of mundane. Okay, we want the seller, Suds Inc., and usually, as I mentioned, you're going to want to say the shareholders of seller to join in these representations of warranty. So Sam Smith and Sarah Smith to represent and warrant to buyer that Suds Inc. is duly organized and in good standing under the laws of the state of South Dakota, blah, blah, blah. All of the documents, this agreement is binding and enforceable. Shareholders have approved this agreement, this asset purchase and sale agreement. Status of the business. That's, to me, a huge one. From the buyer's perspective, the buyer's going to say, seller, I want your last 5 years of financial statements, probably internally prepared. I also want your last 5 years of federal income tax returns. I want copies of them. I want to be able to take them to my accountant and have my accountant look at them. Well, that's all well and good, but if the seller is cooking the books, I want to have a basis for after the closing to go back to the seller and say, you lied to me. You know, you're going to want to say in your representations and warranties that the seller represents and warrants that the internally prepared financial statements for the last 5 years that they furnished to buyer, along with the federal income tax returns for the last 5 years that they furnished to buyers, are true and complete and accurate to the best of the seller's knowledge, et cetera, et cetera. You're going to want to hit that home hard. You're going to want to say that, hey, there aren't any undisclosed liabilities that the buyer's going to be stuck with. The sellers complied with all laws. Next part of that grouping that I think is really important, the suppliers and customers. You're going to want to say seller isn't aware of any supplier that's going to bail on you, or any major customer that's decided they don't like you anymore, they're going elsewhere. If you're going to represent a buyer and I'm selling the business and my major customer who buys 50% of everything I sell has just decided they're walking because they're mad at me, you want to know that. That's going to be a huge hit and affect whether you want to do the deal, or at a minimum, I would think it would affect the price. Employee benefit plans and wages. Presumably, we'll spend a little time on employees in a few minutes, but you're going to want to know what the heck the package is that the seller has for the employees, because if you think that I'm overpaying these employees by way too much, and you're going to cut them in half on salary, well, you're going to want to have to know that. That's probably not going to be received too well. Can I do business if I got to hire a whole new team? Status of the assets. You want the seller to say, hey, to the best of my knowledge, all the assets are in good operating condition. I'm going to keep them up to in good repair pending closing. Conflicts of interest, brokers and finders. We're probably going to say either there aren't any brokers or finders that anybody has to pay, or if there are any, whoever contracted with them will have to pay them. Or if there was a broker, remember way back when we started this, I mentioned how do you sell the business? One way was to hire a business broker. Well, if we know there is one, well, we write it in there. Yes, there's a broker named Joe Smith Broker, and seller's going to pay everything that's owed to Joe Smith Broker. Buyers aren't going to pay anything, as an example. Usually the survival thing at the bottom of the miscellaneous, you're going to want to say that the reps and warranties survive closing. Because, again, if I was lying to you as the seller, you want to be able to come back to me and hopefully get your money back. Okay, representations and warranties of the buyer. You might say, well, why does the buyer need to make any representations and warranties? Well, there are some of them they do. The corporate status is, again, kind of mundane. If they formed Best Inc., I think it was, and they're going to be listed as the buyer in the agreement, we want the buyer and the buyer shareholders to represent and warrant to me that this entity has been formed, it's in good standing, and there you have authority to buy the business, blah, 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 blah. Status of the agreement, that it's enforceable. Shareholders have approved it. Brokers and finders, same. So it's similar, it's just kind of a mirror, but you don't need a whole bunch of things on what about the customers and stuff, because that just doesn't apply from the buyer's perspective in the representations and warranties. Pending closing. Okay, now I got a different section of the agreement. What's going to happen between the time we sign the agreement and the time we close? All right? The seller's going to, you're representing the buyer, you're going to want to say, hey, seller, you're going to operate the business in the normal course of ordinary course. If I have an inventory provision, that buyer is buying my inventory, and if you remember that formula for the purchase price is at 105%, I don't want the seller 3 days before closing to go buy a bunch of junk. So now you can't get in the door because the seller bought a whole bunch of stuff figuring, hey, I'll just make a quick 5% on this. So you want to say operate in the ordinary course. Seller permit buyer and its representatives, hey, we're opening the door. You can come in, you look at our books, bring your accountants in, you can get copies of stuff. It's not reasonable to think you're going to hide all of that stuff and have this kind of an agreement. You gotta tell them. That's why the confidentiality is important. If the buyer is going to come in and look at stuff, maybe they're going to run, if there's real estate involved, maybe they'll run some environmental tests. Well, you're going to want to say, that's fine. You can do all the due diligence inspection work you want to, but you hurt anybody, you damage anything, you're on the hook. If the buyers, will come to contingencies here in probably a minute, but if the buyer says, hey, this deal is contingent upon me, the buyer, getting financing from my bank, then you're, from the seller's perspective, going to want to say, okay, buyer, get your tail in there and get to work on that. Don't wait till 3 days before closing and tell me I've spent $10,000 on my attorney for all this work they've done, and oh, shucks, you can't get a loan in 3 days. So next, buyer promptly apply for it. If there's a franchise, I just can't sell the business and the buyer is off and running, a McDonald's. There's a whole bunch of rigmarole to run through for a franchise. And the franchisor has to approve the transaction. They're going to want to make sure that the buyer is financially sound, so they're protecting their interest, have the buyer sign a new franchise agreement. Okay, we've got a franchise involved. Buyer, get to roll. You're going to promptly do this. Don't wait till the 3 days before. Actions pending closing continued here, I guess. If we're going to have an announcement to the public, to me, you want the agreement to say, we're going to do it jointly. If you're representing the seller, you don't want the buyer sending out letters or taking out an ad in the paper that said, hey, I just signed an asset purchase agreement. I'm going to be buying Joe's business in 60 days. Well, I don't know if that deal's going to go through, and I don't want to have to deal with the fallout if it doesn't go through. Hey, Joe, how come you didn't sell your business? Well, you know, did they find out you were lying to them, or, you know, whatever. You just don't want to deal with that. What about the seller's employees? That to me is a huge one. If you're an employee of a business that's being sold, there's anxiety involved. So usually the seller wants to hey, buyer, shut up about it. And I'm going to shut up about it too when we just signed the agreement. Now, maybe 45 days down the road, if we're going to close it 60 days down the road, now maybe both parties are comfortable that, yeah, this deal's really going to go. You know, nobody's backing off here. And therefore, you might well have a joint meeting with the employees. Bring them all in. You employees have done a wonderful job over the years. I've agreed to sell the Pete here. Pete's a good guy. Pete wants to keep you on, that kind of thing. Normally, however, that might sound like it's an easy thing to do, but the most common way to do this is that you fire all of the employees on the day of closing and you wipe the slate clean. So now I have to pay all their benefits as a seller and pay their vacations and da-da-da-da-da. And buyer goes forward. And why do you do that? Well, buyer may not want to hire all these employees. And if we've got a 50-year-old woman employee, female employee that the buyer doesn't want to hire, they'd rather not have a situation where they take all the employees and now come in and fire and have an age discrimination, sex discrimination, da-da-da-da-da. They want them all fired. Now they say, okay, all of you will reapply and I'll hire the ones I want. They want to avoid that liability. But as an employee, it's disconcerting, as you might expect. I've got a reference to the WARN Act. If you've got a WARN Act issue, I'd say you're doing well because you've got a great client and you're probably doing very well in your practice. It's got some hidden things. The WARN Act it's an acronym for Worker Adjustment and Retraining Notification Act. The concept is this. It's a federal law that says that if you have 100 or more employees and there's going to be a mass layoff or mass closing, that you've got to send a notice to those employees 60 days in advance, at least 60, and you've got to notify a public official. So if it's like Vermilion, if we had an employer that was going to close down, it's got to notify the mayor. This company has to notify the mayor because the mayor needs to say, wow, that's going to affect Vermilion. I need to know about that. But even though you might not know about the WARN Act, the penalties are severe and it could delay closing. And guess what? If you're representing the seller, probably even the buyer, the clients aren't going to be too happy with you that you didn't identify the problem rather than you find out 10 days before the closing that we got to wait another 60 days. You probably got some unhappy clients. I have a reference to the Bulk Sales Act. South Dakota does not have a Bulk Sales Act. It used to. I did various transactions when we did, and I can remember selling a little when they used to have, it was when I first started practice, and still albums were something that were common. I know record albums are popular with some people now too again, but just a little record shop. Should have been a simple thing. I mean, the price might have been $65,000 for the transaction. But South Dakota Bulk Sales Act, we had to notify all the creditors of this little record shop and tell them, we're going to close and it's going to be on such and such a date, and they then would have a right to run in and put a lien on something so that they weren't shorted in the sale. And it was a pain in the neck, and fortunately we did away with that, but some states still have that. Okay, lease. If I'm leasing property that I operate my business out of as a seller, I go back to Suds Inc. The lessor is not dumb. They know that Suds Inc. is a corporation and there's limited liability to the owners. So usually the lessor is going to say, yeah, I'll lease this to you, Suds Inc. I'll lease the building to you. However, I want you, Sam, and you, Sarah, to personally guarantee all of lessee's obligations under the lease. Pretty common, because I don't want to be stuck with Suds Inc. that has no assets. I want your boat if you don't pay the rent. Now, if the buyer is going to assume the lease, first of all, the lease probably says you can't just assign the lease without the lessor's consent. So we're going to have to go to the lessor, hopefully get the consent. But there's a second issue there. If I'm Sam Smith or Sarah Smith, I'm going to say, you know what? I don't want to be on the hook for the guarantee anymore. I sold the business. These best people I'm not so sure if they'll be able to make the tavern run, but I sure don't want to be still on the hook on the guarantee. So now we're going to the lessor, to ask permission to assign the lease, but we're also saying, hey, lessor, I want you to release the personal guarantees of Sam and Sarah. And assuming Bob and Beth are financially sound, one would hope that the lessor would be reasonable and say, fine, I'll release Sam and Sarah, but the assignment will require that Bob and Beth now personally guarantee. So I've got new people guaranteeing. Conditions preceding. Okay, the buyer, if they're going to get a bank loan, you'd write that in there representing the buyer that that's a condition preceding to closing, that they get their loan. Seems to only make sense, but if you don't put it in there, now you maybe have a breach, so you want to put it in there. No material adverse changes. Okay, we signed the purchase agreement today, we're going to close in 60 days. I gave the example of if prior to signing the purchase agreement, the seller has lost their major customer. We want to know that. Well, maybe the major customer bails 30 days after we sign the purchase agreement. So that'd be a material adverse change that would give the buyer a right to bail. The buyer, after going through all their due diligence, having their accountant to review the financial statements, income tax returns, etc., the buyer still wants to do the deal. I mentioned a few minutes ago that usually in these conditions preceding, there's plenty of ways for the buyer to get out. And that's true. That's just part of how this type of a transaction works. You have to do it that way because when you sign the purchase agreement, the buyer doesn't know everything. They haven't done their due diligence review. You probably want to say the buyer wants to make sure that the key employees are going to stay. So they're going to talk to them, and that was what I mentioned before. When do you talk to them? When do you tell them? That kind of thing. And also, you get all the consents that are required. Lessor's consent. If I can't get the lessor to consent to the assignment, then I don't have a building to operate out. I don't want to buy your business. If it's a franchise, if I can't get the franchisor to consent to giving me the franchise, I sure as heck don't want to buy the business. I can't do anything with it. Post-closing obligations, collection of accounts receivable. I mentioned that I'd come back to that. And this is kind of one thing you need to think about when you decide, okay, what assets are you buying and what's the price that's going to be paid? To me, here are the competing things. If the seller is going to keep the accounts receivable, which they can do, the buyer says, I don't want to, your accounts receivable are a mess. I don't want to deal with those people. You just keep them. What you have to worry about from a buyer's perspective is that the seller's a jerk to all of your customers. You know, they're just heavy-handed and they don't have any skin in the game to be reasonably nice with people anymore. So, do you want that? Secondly, whether seller retains the accounts receivable or buyer says, I'm going to buy them at some percentage, maybe it's 100%, but I'm going to buy them. If they're going to be split up, how do I apply the payments? If I sell the business and Joe owes me $100, and the day after we close, Joe buys $200 worth of stuff and makes the payment to the buyer, does the buyer get the whole $200, or does the buyer have to give me, seller who retained accounts receivable, $100? How are we going to apply payments made by these customers who have outstanding accounts receivable? And you'd want to write that out. Indemnification. You're normally going to have a cross indemnification provision. Hey, for the stuff that happened prior to closing with respect to the business, seller's going to save, indemnify, and hold buyer harmless from all acts, liabilities, blah, 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 except for the assumed liabilities. Then the buyer says, for the stuff that happens after closing, buyer's going to save and hold, indemnify, seller harmless from all of that. So that's pretty common, and I hope you think that makes sense. Let's see. If we have seller financing, I mentioned that you're kind of acting like a bank, and banks may have all sorts of restrictions on what a borrower can do. They may say your salary, you can pay yourself as a shareholder a limited amount. We're going to limit your salaries. You can't pay dividends. You can't do all that. So if there's seller financing, you'd think, how much do I want to be like a bank? And if you're going to write all those restrictions that I think aren't very common, but if you do, you're going to have to spend a bunch of time probably putting a loan agreement type document together. If, again, seller financing, you're probably going to want a document that says buyer's going to maintain insurance, because if the place blows up, buyer doesn't have any money to pay you want to make sure there's insurance. And maybe you say, I want financial statements so you can painfully watch them run it into the ground. At closing, what I've found is I like closing to be just really ministerial. Maybe that'd be the best way to say it. It should be a happy occasion. People are a little bit on edge when we go into this room, and I had a closing last week. I had 2 conference rooms full of paper spread all over, and we had to have them walking around signing all sorts of stuff. People are just nervous about all of this. Well, I don't want to have a document on that table the other attorney hasn't looked at. If I'm going to put down a new agreement, I've got problems. So I prepare a checklist. Here are the things we're going to deliver back and forth. Here's the purchase price. Bring me a cashier's check. I don't want you bringing in a personal check. I don't want to deal with that. I'm going to have bills of sale. I'm going to have vehicle titles. we're going to have consulting agreements. Okay? Your attorney's already reviewed them, and we've already gone through the rigmarole in negotiating that. Non-compete agreements, et cetera, et cetera. So everything should be pretty darn straightforward, and we can have hopefully a happy smiles, and people are glad they hired you. Agreements, I mentioned a couple of these just a second ago. Consulting agreements, you don't have to have a consulting agreement, but it's not uncommon to say that the seller is going to consult with the buyer for a period of time after closing. The one I had last week, my clients, the sellers, were kind enough to say they consult for 2 months at no charge, and I'd consult for another 2 months at $20 an hour. So they were very kind. They were on the retiring concept, and so it worked out for them. The non-compete agreements, I've got a reference to the statutory site of 5399. South Dakota looks down upon restrictive covenants. And in order to have a valid restrictive covenant in this arena, the asset purchase and sale, a non-compete, you have to have these things. Number one, you have to have the sale of goodwill. So if you remember way back when I was talking about the section on listing the assets that would be purchased and sold, you list goodwill because that's the basis for my non-compete. Next, I've got to have a specified area. If I'm operating the tavern and somebody wants, in Vermillion, South Dakota, and somebody wants to prohibit me from competing in Florida, having another tavern in Florida, that's not going to be reasonable. So I've got to have a specified area. The supermarket example, we covered 3 states, so we kind of carve out those 3 states. Hey, you aren't going to compete in this area. And then it has to be limited to, the longest you can have is pretty long. The length of time that the buyer operates the business or a successor of the buyer operates the business. That's a pretty long time. Last year in the assignment, people did the non-competes and they put in 3 years or 5 years or something. Wasn't sure why they were doing that. It may be a negotiated deal that the parties negotiate. It's going to be limited to 3 years or 5 years or whatever. That's fine. But if you're representing the buyer and you want the longest you can get, you don't probably want to say 3 or 5 years. You want to say for as long as blah, 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 blah. Parrot the statute. The employment agreements, you can have the seller's shareholders, maybe is a better way to say it, continue on to help the buyer in the form of a consulting agreement, or maybe they're going to be employed for a while. Now let's just talk about a non-compete and employment agreement to contrast it for a second. I didn't put the site there, but that's 53,911. And in South Dakota, you're limited to 2 years or as long as the seller's operating the business, and you still need the specified area. So there is this number of years for an employment deal, but that's not the case in a non-compete in an asset sale if there's goodwill. Leases, if there are any, transfer documents, bills of sale. When we first started out and I listed the types of assets, I had equipment and personal property and supplies and all of that. Well, how do you transfer those? They don't have a title. So you prepare a bill of sale and you probably attach an exhibit with the items that are being sold. If there's real estate being sold, well, how do you transfer that thing? That's with a deed. If there's vehicles being sold, how do you transfer vehicles? Well, you need the vehicle titles. You sign them on the back. If you have leases, etc., you're going to have a separate assignment document that's probably going to be signed by seller, buyer, and lessor, franchisor, whatever it is. If there's seller financing, we talked about that before, what are you going to have? You're probably going to have a note. Then what are you going to have for security? I don't know, but you might have a mortgage. You might have financing statements on the equipment. You might have personal guarantees. I would think you would. Miscellaneous. Fortunately, that's kind of the first one I've listed there has gone by the wayside. But it used to be common that you'd have an attorney opinion letter, and each side would have to have their attorney prepare an opinion letter that would say that all of this stuff is true and correct. And the cat and mouse game was, in writing that attorney opinion letter, you were trying to say basically nothing, and then the other party was saying they wanted to rely on it. Well, it frankly was just, in my mind, a waste of money to the clients because you spent so much time writing gobbledygook, so you were saying nothing. And fortunately, people have kind of backed off of those. So I think that's a good thing. If I remember right on your list of topics, there is someone making a presentation on attorney opinion letters. And that's a big deal from the perspective of your law practice. And I'm guessing they'll stress that. Next one? Oh, good. Then if you need any consents from lessors, we've talked about franchisors, government agencies, those documents would be delivered at closing and should be listed on your checklist. Client matters. I don't think I've ever done one differently, but usually it's going to be an hourly charge. And to do it on a percentage of the price, I suppose you could do that, but that sure doesn't seem to me to be fair necessarily to either party. It may turn out to be more work or less work than you thought. Yeah, you could get creative and say it won't exceed a certain amount. I mean, if you wanted to be an attorney who wanted the work, I think you can make creative agreements that are fair to hopefully the client and to you. An engagement letter, I think it's important, especially with a new client. If you're representing the seller, it may well be that you have a long history. Do you need an engagement letter? Well, I'm guessing the powers that be would say yes. I don't. If you're representing the buyer, it may be somebody who just walked in off the street. Transaction I closed 2 months ago, I'd never seen these people before. They were referred to me. Well, I better have an engagement letter to say, how am I going to charge it? Ethical considerations. If you're representing the seller and the buyer only wants a non-compete and a consulting agreement from Sam, the way I set it up, it looks like it's husband and wife, but let's say it's not husband and wife. They don't particularly care about having a consulting agreement from one or more of the shareholders. They only want it from one. And now Sam comes to you, you're representing seller, and says, hey, I'd like you to work on this consulting agreement with me and represent me and work out the language. You've got a built-in conflict there because the other shareholders in my example aren't getting one. Now, do you need to tell Sam, hey, nope, you've got to go get another attorney? Well, if you're, I mean, that'd be the safest way. You can probably sleep best if you did that. But I don't know how many people do that. I don't. But I sure say, hey, we've got to disclose this. I mean, the other parties are going to see in the asset purchase agreement that you're the only one getting dough under this consulting agreement. And if we've got some pushback, we're going to have to deal with this, and I'm not representing you in dealing with it. I'm representing the entity, presumably. End. Woo! I'm a couple minutes early. You've been very polite in listening to that spiel. I hope it was helpful. It made some sense, I'm hoping. Any questions? If you're ever faced with one of these, I would think that all the presenters would agree, and you want some help, contact a practicing attorney who works in the area, and I'm guessing they're going to be more than happy to help you, guide you, answer questions, and I don't think any question's dumb. You're doing yourself and your client a disservice if you try to wing it and end up in a mess. So that's my 2 cents worth. Thank you very much.
Thank you so much. We did get heard that the roads are pretty bad, like north of T, so those going that way, be careful.